very much for inviting me here to speak to you today. I am greatly honored. The Hindu-Christian Tamils living on the island known as Sri Lanka have been the victims of genocide, as defined by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide by the Sinhala Buddhist government of Sri Lanka. I say that because I single-handedly won 2 world court orders for the Republic of Bosnia and Herzegovina against Yugoslavia to cease and desist all acts of genocide committed against them. I am the only lawyer or government in the history of the World Court, going back to 1921, to have won 2 orders in 1 World Court lawsuit, and that was for genocide. And you can read all of my oral and written submissions before the World Court for Genocide that won these 2 orders in my book, The Bosnian People Charged Genocide. And the fact that the Hindu-Christian Tamils have been the victims of genocide by the Sinhala Buddhist gospel only strengthens and reinforces their right to self-determination under international law, including establishing their own state if that is their desire. Article 2 of the Genocide Convention defines genocide in relevant part as follows. Genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group as such. A, killing members of the group. B, causing serious bodily or mental harm to members of the group. C, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And that's exactly what the gospel is doing to the Tamils today. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. For the past 7 decades, the gospel has implemented a systematic, comprehensive military, political, economic campaign with the intent to destroy, in substantial part, the different national, ethnical, racial, religious groups constituting the Hindu-Christian Elan Tamils. This violates Article 2A of the Genocide Convention, Article 2B of the Genocide Convention, and Article 2C of the Genocide Convention, and that goes on today, inflicting on the Tamils conditions of life calculated to bring about their physical destruction in substantial part in violation of Article 2C of the Genocide Convention. With all due respect to my previous speakers, this is not structural genocide. This is actual genocide under Article 2C of the Genocide Convention, inflicting conditions of life calculated to bring about their physical destruction in whole or in part. Now, some have argued that this is not genocide because the gospel has not intended to exterminate all the Tamils on Sri Lanka. Well, I had encountered this argument in my World Court proceedings for Bosnia, where the genocidal rump Yugoslavia was represented by Shabtai Rosen of Israel, who was supposed to be the world's leading expert on the World Court, until I demolished him twice in a row. Rosen got up there and argued that since he was an Israeli Jew, this was not the same thing where the Nazis had intended to exterminate all of the Jews, and therefore it was not genocide. Indeed, I pointed out to the World Court against Roseanne that the Genocide Convention says, quote, in the present convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethical, racial, or religious group as such. So what I argued to the World Court, and that what they eventually agreed with me, is that a government only had to intend to destroy a substantial part of a group, not the whole group, which of course is what the Nazis and Hitler intended to have done with the Jews if they could have gotten a hold of them. And indeed, certainly Yugoslavia intended to do the same thing to the Bosnian Muslims if they could have gotten away with it, as proven by their mass extermination of 7,000 plus Bosnian Muslim men and boys at Srebrenica in July of 1995. I would later become the attorney of record for the mothers of Srebrenica and Podrina, as well as the women for Srebrenica, at the International Criminal Tribunal for the former Yugoslavia. I convinced the ICTY prosecutor, Carla Del Ponte, to indict Yugoslav President Slobodan Milosevic for every crime in the ICTY statute for the atrocities he inflicted on the Bosnians, including 2 counts of genocide, 1 count for genocide in general, and the 2nd count of genocide for Srebrenica in particular. Notice, as far as the ICTY was concerned, the International Criminal Tribunal for the former Yugoslavia, 7,000 murdered human beings were enough to constitute genocide. Milosevic died while on trial at The Hague after the ICTY itself denied his motion to dismiss all these charges at the close of the prosecution's state case and sustained all the charges against him, including and especially 2 counts of genocide, genocide in general for Bosnia, and genocide in particular against the 7,000 Bosnian Muslim men and boys at Srebrenica. I went after Milosevic in 1993 at the World Court, and finally he was brought to justice in 2006. The wheels of international justice turn slowly, but they do turn. Now, in the argument for what was a substantial part for genocide, I argued to the World Court that at that time, the best estimate we had was that about 250,000 Bosnian Muslims out of a population of about 4 million Bosnians and 2.5 million Bosnian Muslims were dead. So I argued to the World Court that 10%, 250,000 dead Muslims, were a substantial part of the Bosnian Muslim group, and that the proper interpretation of the words in part in Article 2 of the Genocide Convention meant substantial part, and 250,000 dead were enough to do it. The World Court emphatically agreed with me, completely rejected Roseanne's arguments that he had made twice, and gave me these 2 World Court orders on 8 April 1993 and 13 September 1993 that were overwhelmingly in favor of the Republic of Bosnia-Herzegovina against Yugoslavia to cease and desist from committing all acts of genocide against them. In the final judgment on the merits in the Bosnia case on 26 February 2007, the World Court definitively agreed with me once and for all time that in order to constitute genocide, a state must only intend to destroy a substantial group, a substantial part of the group as such. My paper has the exact language that I won't repeat here. But according to this World Court decisions, in order to find the Gassel guilty of genocide against the Elam Tamils, it is not required to prove that the Gassel has the intention to exterminate all the Elam Tamils. Rather, all that is necessary is to establish that the Gassel intends to destroy a substantial part of the Elam Tamils, which they have already done in Vani. Furthermore, in its 2007 Bosnian judgment, the World Court found that you did not even need 250,000 exterminated Bosnians to constitute genocide, let alone 6 million dead Jews. Rather, even the 7,000 plus exterminated Bosnian Muslim men and boys at Srebrenica were enough to constitute genocide as far as the World Court was concerned. Well, since the World Court ruled in February of 2007 in the Bosnia judgment that the extermination of 7,000 Bosnians at Srebrenica constituted genocide, then certainly and in spades, the Gassel extermination of about 146,000 Tamils in Vani only 2 years later, in May of 2009, also constituted genocide. Nothing could be clearer that this was genocide, and it is continuing genocide. Again, with all due respect to my previous speakers, this is the Gassel deliberately inflicting conditions of life on the Tamils calculated to destroy them in significant part in violation of Article 2C of the Genocide Convention. In order to prevent the ongoing genocide and another wholesale slaughter by the Gassel against the Elam Tamils, Article 1 of the Genocide Convention requires, quote, the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. To prevent and to punish. Pursuant to these two obligations, I respectfully submit that the time has now come, and for this conference to undertake to prevent and punish the Gassel for its still ongoing genocide against the Tamils by founding here and now a boycott, divestment, and sanctions campaign against the genocidal Gassel. So, if you're asking me what can be done and how can we do it, a BDS campaign is it. Go back and study what the entire world did to dismantle the racist, genocidal, apartheid Afrikaner regime in South Africa. that was doing pretty much the same thing to its 30 million black inhabitants. We had a BDS campaign against them, and it worked. I was involved in large numbers of cases in the earlier apartheid BDS campaign against them, defending anti-apartheid resistors. You can read all about this in my book, Defending Civil Resistance Under International Law. These books on reserve on Amazon. This included obtaining the first acquittal ever of anti-apartheid protesters in Chicago at the South African Consulate, Chicago versus Streeter, 1985. We even made the New York Times on that one. I know apartheid and genocide when I see them. I've litigated against them all over the United States, at the World Court, and around the world. And that is what we are dealing here with the gospel. It's time to take the kid gloves off. Let's set up this BDS campaign. The South African BDS campaign, we were up against some of the top law firms and lobbying firms in the United States. But eventually, they lost and we won because we had truth and justice on our side. And today, there is no racist genocidal regime in South Africa. Sure, they have their problems. We have a lot of problems here in Canada. We have problems in the United States. But genocide and apartheid are not two of them. So this is not a case of us reinventing the wheel here. We already have the wheel. Now, there's no way in this brief presentation I can deal comprehensively with all the legal reasons for and strategies behind dismantling the racist apartheid regime in South Africa. Again, you can read those in my book. And the materials set forth in that book were used all over the United States to help dismantle the racist genocidal apartheid regime in South Africa. Almost identical legal arguments and strategies can be applied to dismantle the racist genocidal apartheid Sinhala Buddhist Gassel regime. To the same effect is the Palestinian boycott, divestment, and sanctions campaign against the Zionist regime in Israel. The historical origins behind and legal arguments in support of the Palestinian BDS campaign against Israel can be found in my books, Palestine, Palestinians, and International Law, and Breaking All the Rules, bringing it up to date to 2008. Today, the Palestinian BDS campaign against the racist, genocidal apartheid regime in Israel has spread all over the world. It was recently nominated for the Nobel Peace Prize. Almost identical legal arguments and strategies can be applied to dismantle the racial, genocidal, apartheid, Sinhala Buddhist regime. Go after the Sinhala Buddha money. People's precious money is something everyone in the world understands and appreciates. Going after their money was something the racist, genocidal, apartheid regime in South Africa well understood. And because of that economic motivation, in significant part, they ultimately released Nelson Mandela, commenced good faith negotiations with the ANC, and their regime was dismantled. The Bantustans for black inhabitants of South Africa were also dismantled. And today, black citizens in the apartheid-free Republic of South Africa are now able to determine their own future. The Elam Tamils can do it too, and can do it the same way. I cannot predict the future, but given the heavy dependence of the already bankrupt Gassel regime and its economy on imports and exports such as tourism, textiles, teas, overseas remittances, I think a worldwide BDS campaign against the Gassel can bring them to their knees in no more than a decade. And that's what we need to do. Bring the Sinhala Buddhist, racist, genocidal regime to their knees. And maybe sooner than 10 years. And then the racist, genocidal Sinhala Buddhists will have to deal with us. But only when we've done that are they going to deal with us to bring them to their knees like we did with the apartheid regime in South Africa, like we are doing today against the apartheid genocidal regime in Israel against the Palestinians. The Gassel is not going to do it for themselves. This notion of transitional justice, even Professor Kasese, who was the chief judge of the International Criminal Tribunal for the former Yugoslavia, said, and I agree with him, transitional justice does not work when there has been genocide perpetrated such as Bosnia. And I can testify to that. I had a meeting with my friend, Mr. Finci, the head of the Bosnian Jewish community in Bosnia. The Bosnian Jews were my clients too. I argued their case for genocide to the World Court. Mr. Finci set up a transitional justice campaign in Bosnia and asked me to support it. I did. It got nowhere. With all due respect to Mr. Finci, he did the very best he could. Transitional justice does not work with genocide. What's going on in Geneva today, it's just stall and delay while the Gassel continue to inflict conditions of life calculated to bring about the physical destruction in whole or in part of the Elam Tamils in violation of Article 2C of the Genocide Convention. The United States is not going to help us. They were in on the massacre at Vanni. The United Nations organization is not going to do it. It is up to you and me to do it. We must take the future of the Elam Tamils and Tamil Elam into our own hands. Found the anti-Gassel BDS campaign. Stop the ongoing Gassel genocide against the Elam Tamils and Tamil Elam. Start the Tamil BDS campaign here and now. We will have truth and justice on our side. And for that reason, we